Good afternoon, everyone, and welcome to the Committee for Justice's virtual panel discussion, State Antitrust Law and Enforcement by Attorneys General. I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. And I'm now going to introduce our two expert panelists in the order in which they're going to be speaking. Paulin Watkins is Managing Director at Potomac Global Partners. His regulatory background includes designing the first state and federal fintech sandboxes, consumer protection and antitrust enforcement, securities litigation defense, and helping to found the first international and domestic regulators networks promoting innovation in financial services. Mr. Watkins joins Potomac from the Consumer Financial Protection Bureau, where he founded the Office of Innovation and was the Bureau Director's primary advisor on innovation. He designed the Bureau's policy of no action letters, trial disclosures, and compliance sandbox test. Before joining the CFPB, Mr. Watkins led the Civil Litigation Division of the Arizona Attorney General's Office, where he managed the state's enforcement of consumer protection, data privacy, antitrust, and civil rights laws. He supervised numerous multi-state and individual enforcement actions against companies ranging from Theranos to leading financial institutions, credit reporting agencies, and technology companies. He routinely built multi-state attorney general coalitions in the consumer protection and amicus brief context. Timothy Sandifer is the Vice President for Litigation at the Goldwater Institute's Center for Constitutional Litigation and holds the Duncan Chair in Constitutional Government. He litigates important cases for economic liberty, private property rights, and free speech in states across the country. Timothy is the author of several books, including Frederick Douglass, Self-Made Man, The Conscience of the Constitution, and The Right to Earn a Living, as well as dozens of scholarly articles on subjects ranging from Indian law to antitrust, slavery, and the Civil War, and political issues in Shakespeare, ancient Greek drama, and Star Trek. The brief presentations by our panelists are going to be followed by a discussion, after which we're going to have Q&A from the audience. Just a quick housekeeping note for the Q&A, if audience members could please send me their questions through the Q&A button at the bottom that you see at the bottom of your screen. And that way I can ask the questions from my end whenever there's time. And you can go ahead and send those to me whenever you would like throughout the panel. And with that said, Paul, the floor is yours.
Well, thank you so much, Ashley. I appreciate the opportunity to be here. And thank you to everyone tuning in and choosing to spend your Friday before Thanksgiving, immersing yourself in antitrust. And I'm glad to be here. So as Ashley indicated, I've been spending a lot of time recently on fintech, on financial technology. So when I'm talking about antitrust, I want to sort of merge those two topics a little bit, because I do think that they relate, especially when we come to this core issue in antitrust around how to define the market. So let me start broadly here before I get down to that antitrust problem of the market. We have a general problem in the US with our regulatory structure in that we attempt to silo products and we attempt to silo markets. This is not an accurate description of the world as it exists now. And it is even a less accurate description of the world as it is trending. Let me give you an example. You may have heard a few weeks ago, the administration blocked a product called WeChat. WeChat's a Chinese company that combines social media, commerce, payments, and a number of other things in one app. You can sort of think of it as Facebook, Twitter, Amazon, Venmo, all together. It's wildly successful in China. It's starting to gain traction in other markets as well. The reason is because consumers love convenience. They want to have these things together. And this is establishing a new paradigm that the US from a regulatory perspective is not prepared for. If we were to regulate a company like WeChat, it would be subject to a number of different federal financial regulators, and the markets, as some antitrust enforcers are defining them, would be substantial. I can't imagine how many markets an antitrust enforcer might identify as WeChat as touching. But in fact, it is one market. That market is consumer convenience. This is what consumers want. They want an integrated system. We are heading toward a world where the consumer will be sitting on the couch, ordering with their voice products, the payments, the delivery, everything will be happening automatically. We're very close to being there already. This is a single market. Dividing it up into little pieces no longer makes any sense. And let me give you an example of how that no longer makes any sense. The Department of Justice brought an antitrust action to stop a merger between Visa and Plaid a couple of weeks ago. Visa is a company I assume everybody has heard of. Plaid, some of you may not have. Plaid is a data aggregator. This is a company that interacts between banks and fintechs through APIs, through portals that they develop for banks. So if you've used Venmo to send money to your friends, you've used Plaid. Plaid is the interface between your Venmo account and the bank account that directs where the money's coming from and where the money's going. So this antitrust action was based on Visa's market share in online debit payments, where Visa has a substantial market share, maybe 70%. The complaint says Visa, this is a quote, and this is a quote that I believe will not age well in history. Visa rarely faces any significant threats to its online debit monopoly. I believe that Visa, in fact, faces substantial threats to its online debit monopoly because the market is not online debit. The market is payments. There are mobile payments. There are all sorts of products arising that are posing challenges here. And so the antitrust action was brought because the theory was that Plaid was developing a product that could compete with online debit. And so therefore, this acquisition was going to restrict competition in the future. So the theory is this product may be developed in the future that could pose a competitive threat to Visa. Visa bought the company. This is an antitrust problem. Well, ironically, recently, a little startup out of Silicon Valley called Google announced a product that they have where they are incorporating bank accounts into their Google interface as well as Google Pay, and developing a new product that will enable closer interactions with consumers through Google with their bank accounts. The exact contours of this product aren't fully developed. Who knows exactly what shape it will take, but we know that Google Pay is present all over the place and that it is an easy way to pay for all sorts of products. And I would be shocked if this product did not someday compete with online debit in a substantial way. Now, the DOJ had no idea that this product was coming to market. I don't know if Visa did or not. But the point is, this market is changing in a dramatic way that antitrust enforcers cannot predict. Nobody has this kind of knowledge. And so when companies attempt to protect their product, when companies attempt to prepare for future competition, if they're being met with antitrust actions, that in effect is paving the way for other competitors to come in through another route and capture that market share. The action by the DOJ actually in this case is particularly troubling because there was a similar transaction occurring at the same time. MasterCard purchased a company called Finicity, which is also a data aggregator. That transaction is closed. No antitrust action brought there. So if you're Visa or if you're Plaid, you're facing this antitrust action. There's a status conference scheduled for the spring of 2021. Plaid just asked to have this moved up so that they can get a decision and move on to determine if this transaction can go through. The DOJ refused. So now there's going to be this long, drawn-out litigation. Meanwhile, other competitors are entering the market. They're building their offerings. I believe that this will be a case study in the future of how antitrust is applied in a way that does not take into account the competitive effects and the changes in technology and these developments that we are seeing toward unified product offerings. The question should not be, why is Visa purchasing Plaid? The question should be, why is Visa not purchasing Plaid and Bose speakers and Overstock and TikTok and building a consolidated product offering that provides consumers the sort of convenience that they're going to demand and are already demanding. Now, the Supreme Court, I think, has some idea that this is the way the world is going, that these are the demands that consumers are seeking. And you can see this a little bit from a decision a couple of years ago that was brought by the states and the Department of Justice called Ohio versus American Express. This was about American Express's contractual practices where they would prevent merchants from steering consumers to using lower priced products. And the Supreme Court said that when you're analyzing the market, you take into account both sides of the market, both the effect on consumers and the effect on merchants, recognizing that these are complex, multi-sided markets. I'm somewhat familiar with this case. When I was in the Arizona Attorney General's office, we were part of this lawsuit. We were part of this lawsuit up to the Second Circuit opinion. At the Second Circuit, Amex somehow drew a panel with Judge Wesley and Judge Winter. I think they may have both been on senior status at the time, but somehow this was the panel that Amex drew, and they wrote an opinion that was fairly similar to the opinion that Justice Thomas later issued, describing this two-sided market and ruling in favor of American Express and against the states. And after reading that decision, we in Arizona, under General Brnovich's leadership there, decided not to pursue an appeal because we believed that the court got it right. And a number of other states followed our lead. So we withdrew at the en banc stage. A number of other states withdrew at the Supreme Court petition stage. DOJ changed its opinion as well. And the final decision ended up being very close to the panel. And I think that there are elements of that decision that will be very relevant moving forward as these complex technological markets are analyzed. And my hope will be that there is recognition on the part of regulators of the intense competitive dynamics that are occurring, not just domestically, but also globally. We continually make demands on American companies that they compete globally. We issue strategic visions. We describe critical technologies that we want America to lead in. And yet, when companies attempt to do that, when they attempt to build globally leading brands, we too often put regulatory requirements or enforcement actions in their way and inhibit that progress. So thank you very much, and I'll turn things back to Ashley or over to Tim.
Thank you. Timothy, the floor is yours.
So what Paul has been talking about the defining the relevant market is just one of the persistent problems with all antitrust law, and one of the sources of complaint about antitrust law since its inception, which is primarily its vagueness, that it's the terms that these laws use are so broad that it makes it virtually impossible in many, perhaps most cases, for businesses to really know whether what they are doing or planning on doing is legal or not. And this problem is compounded by something that we often don't talk about in antitrust law, and that is state antitrust law, as opposed to federal law. We typically, when we're talking about antitrust law, almost always we're talking about the Sherman Act and things like that. But the states, many of them have their own antitrust laws, and these, unfortunately, are often more problematic than the federal ones. And the primary driver of that, I think, is the fact that some states have failed to follow developments in federal antitrust law that have helped to open up markets in the past half century or so. So the primary one of those, of course, is the adoption of the consumer welfare standard at the federal level, which is, the result of a movement of scholars who said, we really shouldn't be just out there punishing businesses for doing a good job or for getting big and successful and charging low prices for goods people want to buy. Instead, we should focus our attention on whether the behavior that these businesses are engaged in is harming the consumer or not. And that has led to antitrust jurisprudence at the federal level that has been protective of free markets and efficient markets. But that has not happened at the state level. And this remains a persistent, though fortunately so far underutilized, weapon against businesses in certain jurisdictions. Now I'm going to talk about California because that's the one that I'm most familiar with in this respect. California has 3 antitrust laws. It has the Cartwright Act, the Unfair Practices Act, and then its general unfair competition law, also known as 17200, which is so vague. We like to joke and say that the unfair competition law makes it illegal to practice competition that's unfair. I mean, that's basically what the statute says. Well, when you look at how these laws are implemented, what you find is California courts expressly rejecting the pro-freedom developments that have taken place at the federal level. And some of them include these problems about defining markets. There was a case in 1997, is a good example of this, a case called ABC International Traders versus Matsushita. And this was a case where you have a company that sells telephones, and they find out that their supplier is providing discounts to other sellers of telephones that they're not getting, and they sue over that. Well, you couldn't do that under federal law because under federal law, the primary focus would be, is this harming the consumer or not? But the California Supreme Court rejects that approach, and it says the reason why you would sue is, in theory, is, well, we don't want sellers to consumers to be providing discounts or rebates that provide for an unfair market vis-a-vis those two parties. But if you allow another business to sue its supplier for that reason, what you're doing is you're prosecuting what they call vertical as opposed to horizontal behavior. And that means that you have a business versus business dispute where the activity that's being objected to has market efficiency reasons for it, legitimate market efficiency reasons for it. So the California Supreme Court, rather than take that approach, it says, no, we expressly reject the consumer welfare standard as a matter of state antitrust law. And they say this right out. They say the purpose of federal antitrust law is to protect consumers, but the purpose of California state antitrust law is to protect businesses against competition, which is a really shocking and terrible approach to take. And of course, there's only one dissenting opinion in that case. It's by one of my favorite judges, Janice Rogers Brown, before she was placed on the DC Circuit Court of Appeals. She says, quote, "This case involves competition among distributors of the same product, competition that cannot conceivably have a significant effect on the touchstones of antitrust policy, interbrand competition, the structure of competitive markets, and so forth." And what the majority says in response to that is, well, that's just the current economic fashion among economics scholars, and we're not going to follow that path. So as a result, the court says businesses can sue businesses even where the consumer is benefiting from the behavior that results. And a consequence of that is you have another case. I don't remember the title of it off the top of my head. It's called Fisherman's Wharf or something like that. But what it involves is, when you go to San Francisco, you want to take a trip to Alcatraz. There's 2 boat lines that handle that kind of trip. There's the red and white line, and there's the blue and gold line. And the red and white line accuses the blue and gold line of selling tickets to ride the boats, selling wholesale tickets at below cost. Now, wholesale tickets means tickets that they sell to hotel concierges or to travel agents or to the people who will arrange you a one-size-fits-all trip to San Francisco, as opposed to the walk-up booth. When you walk up and buy a ticket for yourself, that's considered retail. And the reason that distinction is important is because the defendant says, wait a minute, we charge way above cost for our walk-up tickets. So if you average that out, it turns out we are not charging below cost for our tickets, and therefore we have not broken the law. And the plaintiff says, no, you have to divide these tickets into two separate markets and conceptualize them as two different things. And now we have monopoly behavior in the wholesale market that we've just arbitrarily drawn. We've just arbitrarily drew these lines basically to facilitate the outcome that we want in the case, because there is no difference in substance between these two tickets. And the court allows that to go ahead and again says, because we do not adopt the consumer welfare standard as a matter of state law. And there's an even worse case, and I'll close with this, a case called Bay Guardian versus New Times, where one newspaper sues another newspaper for charging below cost for advertising. Now, below cost lawsuits, those are the theory there is predatory pricing. And the idea is, well, one business might charge really low prices for something and drive all its competitors out of business. And then once his competitors are all out of business, then they'll raise their prices up again and then they'll reap monopoly profits. Of course, the problem with that theory is if there are no barriers to entry in the marketplace, there's no reason why a new competitor couldn't just enter the market the instant the alleged predator tries to raise his prices. If I charge below cost for my bread at my bakery and I drive all the other bakers out of business, and then I start to raise the price of my bread loaves, all the bakers are going to start firing up their ovens again, unless I have some kind of barrier to prevent them from doing that. And as a result, the US Supreme Court has said that in predatory pricing cases, you have to prove that the alleged predator has some plan in place to recoup the losses that he's going to incur when he charges less than cost, because obviously it's very expensive to charge less than cost. And in a case called Brook Group versus Williamson Tobacco Company, the Supreme Court says plaintiffs have to prove that the defendant had some scheme in mind to recover how much he's going to lose in this way. And because that's very hard to prove, because nobody ever really engages in this kind of behavior in the real world, therefore, you really don't find a lot of these kinds of cases at the federal level. But the California courts take a completely different approach. They say, no, our laws aren't in place to protect consumers. Our laws exist to protect businesses against competition. So here's what they say in this newspaper case, quote, a primary concern in the enactment of the Unfair Practices Act was the protection of smaller independent retailers, especially grocers, against unfair competitive practices of the large chain stores. As a contemporary commentator explained when the law was passed, the prohibitions on secret rebates and unearned discounts are designed to protect the retailer whose more powerful neighbor is attempting to drive him out of business, end quote. So as a result, plaintiffs have to prove that the alleged predator is cutting prices in order to harm competition. How do you prove that somebody's trying to harm competition instead of just trying to win a competition? Well, that becomes deeply subjective. The courts have said you can prove that through even circumstantial evidence. In fact, in below cost cases, the courts will infer that. They will presume that the defendant was doing this on purpose in order to harm their competitors. And as a result, you have a situation where California antitrust law, aside from your federal concerns, California state antitrust law is really like, an anvil hanging over the head of Wile E. Coyote in the old Warner Brothers cartoons. And it's really only a matter of good fortune that it has not so far fallen on that many businesses. I think this is a major concern going forward. We're going to have to pay attention not just to what federal regulators do under the federal antitrust laws that exploit the arbitrariness and vagueness of existing statutes, but also what state attorneys general are doing and how they're going to exploit their own state law as well as federal law to penalize businesses in ways that are not, to put it politely, are not primarily concerned with the welfare of the consumer.
Thank you, Timothy. So to start the discussion, why don't we kind of take a big step back and look a little bit at enforcement authority and the authority of the states, to bring these suits. There's obviously a lot of overlapping authority to bring suits under federal antitrust law. As most people in this call know, with both Facebook and Google right now, we have on one hand the FTC bringing a suit, and then we also have like 3 or 4 concentric state investigations by coalitions of several states, and then with Google and the DOJ, we have kind of a similar dynamic. So I guess my question initially aimed a little bit towards Paul, since you've been on the enforcement side of this. What are kind of the dynamics in bringing these suits, and why are these? It seems as if all these states band together, then they end up just hopping aboard the federal suits anyway, and there's a lot of overlapping authority here.
Yeah, that's your suspicions are exactly right, Ashley, as I can tell from the question. And let me talk a little bit about the multi-state process at the state level for folks who aren't familiar with it, because this is an important dynamic both in consumer protection and in antitrust. So the state antitrust divisions are much more leanly staffed than the DOJ. So for example, we had 3 or 4 folks in Arizona for antitrust. And if you're familiar with antitrust litigation, extremely document intensive, lots of experts, because again, you're dealing with these big questions about the market. So what the states will do is pool their resources, join together. There are funds that they can tap into through NAG, National Associations of Attorney General. They can apply for a grant to support an investigation and hire an expert or some outside folks to assist with this, but they'll try to pool their resources to make it through the documents and conduct these investigations. And they'll also try to partner with the Department of Justice, which has much more substantial resources and for these matters. I'm very curious to hear Timothy's description of California antitrust law, because I'm less familiar with it. But most of the time, it was more favorable for us to use the provisions of the Sherman Act that allow state enforcement than to use state antitrust law. And it had various reasons for that. But I'm curious if that's also the case in some of these California cases, if they're still using the federal law, or if they're using state law. So anyway, that's how you get these large coalitions, and they'll usually be a leadership committee. One state will step forward, or a couple states, and they'll chair the leadership committee. Leadership committee will make a lot of the decisions, do a lot of the work, and then decisions on when to file, when to settle, are initially made by that state leadership committee, and then eventually made by all the participants. So that's the general structure, why they bind together, and why they end up using federal law a good chunk of the time.
And I mean, historically, we've seen this too. I mean, can you talk a little bit about like Amex, or the role that states played in the Microsoft case and kind of banding together and hopping on a federal suit? I mean, it does seem like a tremendous waste of resources to do that to enforce federal law, as opposed to them going after state law in one state capacity. And this actually ties into one question that I've already gone through Q&A, so I'm gonna go ahead and put that out there. Isn't there some tension between state antitrust law and the Commerce Clause?
Is that I'm happy to jump in there, unless I mean, yes and no. So I mean, maybe state antitrust law, but then, I mean, if federal antitrust law has authorized state enforcement, then I guess there's probably less of a Commerce Clause issue, because this is apparently the way that the federal government has chosen to enforce antitrust law. And maybe that wasn't a very good idea, but that's seems to be a federal issue and not a state issue. I don't know if it would make more sense to have 50 different suits against Microsoft. I kind of think that would not make sense, that it is a national market, that it makes sense to address it as a national market. And so this sort of cooperative behavior is probably something that should be encouraged, and that there would be more inefficiency and more waste if in fact everybody were suing individually. But I'm curious to hear what Timothy thinks about that point.
And I didn't mean to imply that they shouldn't sue individually. I just meant, as opposed to bringing federal, suits under federal law versus, other suits under state law for, whatever else the department would want to put its resources to, not necessarily
Right.
Microsoft.
Right. Well, so, and just on that point, I can see someone saying, well, if you have antitrust enforcement by the DOJ, by the FTC, and then by the states, should you really have to check 3 boxes to accomplish a transaction, and isn't that inefficient? That seems to be maybe a stronger argument, but then again, you have the issue at the federal level too, where you have very similar jurisdiction by 2 agencies, and you have to talk to both of them.
Yeah, when we run into that kind of situation in other legal contexts, often the way that it's been handled is with what they call cooperative federalism, where the federal government will set substantive standards and say the states have to either accomplish those substantive standards on their own, or then we'll step in. And that might be an approach that in some alternate future world they might take to resolve the problem of 50 different independent suits. But I think if you look at the history, I think it's clear that when Congress adopted the first antitrust laws, I think they had in mind the idea of state attorneys general would really be in the driver's seat, filing under state law lawsuits against businesses that were engaged in objectionable behavior or whatever within those state boundaries. And the problem was supposedly they didn't have authority across state lines, and so then Congress comes in and passes this federal law. But I think that Congress probably at that time still had in mind this idea that the states would be the primary drivers. I don't think it was really until the New Deal era that you see that mentality shifting and it becoming just the default presumption to that it would all be a matter of federal law, to such a degree that many people don't even know that their own states have state antitrust laws. And incidentally, I talk about California because it's a very clear example. Other states, including Arizona, I think if this is right, Paul, I don't have a distinct antitrust law. They have an unfair competition law, and then antitrust legal theories are embedded in that or drawn out of that for purposes of litigation.
I'm pretty sure Arizona has a separate antitrust law. But we certainly have an unfair competition. We should certainly have an unfair competition law as well, and that's used much more frequently.
And remember, these unfair competition laws, like California 17200, for instance, they can be used as and this is, I think, very objectionable. They can be used not only to sue over things that substantively are not problematic. I mean, you see an incredible number of frivolous unfair competition law cases in California, but they can also be used to bootstrap standing in ways that would not be authorized under federal law. Federal laws that say, you're not allowed to do X, but only the attorney general can enforce this law. You go to California, you can still sue in state court on that theory by using the substantive illegality of the conduct and calling that unfair competition, and now you're only suing under 17200. And California courts have allowed that to happen. So it allows plaintiffs an end run around the limitation on standing that Congress puts into its statutes, thinking that will solve the problem of a million people racing to the courthouse.
Yeah, and you see that in privacy law a lot in California and other states as well. And one thing regarding, maybe this isn't necessarily Commerce Clause violation, but there is some tension in the fact, one state AG can essentially raise their hand and block a merger. So that does have, implications for interstate commerce. Isn't that, just broadly speaking, though, isn't that a lot of power for one state AG to have?
Well, you still have to have jurisdiction within your state. So in some circumstances, if there was a problem with a specific state, you could sell assets in that state. So there may be ways to get around it, because the AG still has to have jurisdiction.
That makes sense. Let's see. So what are kind of some of the incentives to bring these? So I mean, to give kind of a idea of the landscape right now, not incentives, what a different question actually. I'm curious about is, and maybe this is something being part of the process, Paul, you would have an answer to, the level of like kind of communication between the DOJ and the state AGs. So for, let's say the Google suit, for example, like for months, we've had, various pending state investigations saying, oh, is it going to be about the ad tech market? Is it going to be about something else? And it seems that if states were kind of holding off to see what the DOJ suit was about, and maybe, I don't know if there's communication there or not, but not, even pertaining to that case specifically, when, at the end of the day, you have the result of a lot of, states jumping onto the federal suit. Leading up to that process, are they necessarily, are they discussing the suit? Is the investigation in any way cooperative?
So that's such an interesting question, because it varies so much, and it really gets down sometimes to the personalities of the folks in charge or running the investigation. So I've had experiences where we were initially part of an investigation. We raised questions, said we'd like to go a different direction. We think you should be emphasizing this, not emphasizing that. Sometimes people are amenable. Sometimes they say, get out. Sometimes we say, okay, we're out. And then they'll just shut off all access. I had one part of one multi-state where we left the multi-state over a disagreement, and they shut off access to the documents, I think half an hour later. So a very aggressive posture of, if you're not going to be part of supporting my state AG, then we're going to try to make it hard for you to bring a lawsuit at all. Now, it ended up that we got a settlement that was about 3 times what the other state got, so it didn't hurt us at all. But what I would hope that there is a cooperative posture between the states and the DOJ, and I suspect that generally there would be. Generally, you can enter into confidentiality agreements and share documents and share efficiencies that way. But at the same time, if people have legal theories that they believe are the best for their state, best represent the will of the folks that the people elected as AG, or that the president selected, then they should be free to pursue their different theories. I don't think that it's the case that the folks with the most resources should always dictate what the claims are and how a lawsuit proceeds.
Ashley, that question kind of reminds me of the article that you shared with me by Judge Posner about state and federal enforcement of antitrust law. And he raises this real concern that there are types of relief or degrees of relief that aren't available as a matter of federal law, but under the analogous state antitrust laws, those avenues of relief are allowed. And so you have a conflict. They're not like a direct conflict in the sense that you have the same statute. You have 2 different statutes that purport to enunciate 2 different causes of action. And like what I was just talking about California, these are substantively different causes of action. You have to prove different elements for them. And yet they amount to the same concept in theory about, something like, I don't know, predatory pricing or whatever it might be. And a recovery of a certain number of damages would not be available under federal law, but are available under state law. Plaintiff brings both, is denied that kind of recovery under the federal claim, is permitted it under the state claim. Really, that should be some kind of preemption that prevents that from happening. Or at the very least, you have a real problem. You're right, Paul's right, it's not technically a violation of the Commerce Clause because Congress has allowed states to do this. But it certainly raises serious Commerce Clause problems, especially when you're talking about a market like California, where 1 out of every 10 Americans lives in the state. So this is a major market to be concerned with.
Well, this problem is a lot broader than antitrust, though, isn't it? I mean, this is a problem for double jeopardy. Double jeopardy doesn't apply to state criminal charges versus federal criminal charges. So this is not so much antitrust, I think, just flows from the federal system.
Yeah. And as a reminder, if anyone who has questions can send them through the Q&A to me. One thing that'll be interesting, in coming months is, I mean, there is obviously some partisan element to these suits, and at least to, how which coalitions form. You have the Republican attorneys general in one suit specifically, and now we have a change in administration. Any predictions on how that will play out, or how that will affect other suits, or how that affects, other coalitions forming?
That's such an question. I'm not sure that there will be that much shakeout. This seems to me to be an area where the parties are pretty well aligned, and maybe for different reasons, maybe for the same reasons. But there seems to be bipartisan skepticism against the authority of some large companies, and folks at least want to investigate that, if not bring actions against it. Now there are always personalities at play. There's always different theories, especially when it gets to settlement, as to what is an appropriate resolution. That's where things might get interesting, to see whether those coalitions split off and there are different settlements. The defendant, of course, always wants to settle everything at the same time. But in this particular instance, when it comes to some of the terms, that might be pretty difficult. And this also might be a case that is tested, that goes to trial, that goes all the way up. Because I think if the other branches of government are pretty aligned in their skepticism, I think the Supreme Court, at least as indicated in the Amex decision, might be the most favorable venue for this sort of argument to be litigated, as opposed to the public sphere or the political sphere.
I'm personally very concerned. I think that I agree with everything Paul said. It's just I see I would say it from the exact opposite side, I think, of the screen, which is to say that the skepticism, I wouldn't use that term, say that both parties are ramping up aggression against free enterprise institutions, and every business in the country should be afraid of that. The populist antitrust approach that we've seen aired by prominent Republican voices is a really serious concern, because at least up until recently, it was Republican voices who at least provided some maturity and some restraint on the aggression of the antitrust enforcement in this country. And seeing that bulwark of market efficiency and consumer welfare standards, seeing those things questioned by the side that was at least nominally pro-free market, is extremely worrisome. And of course, we can expect the Biden administration to use antitrust law to demonize businesses and for demagogic reasons to sue against companies that really are not monopolies by any legitimate definition, but are simply successful and politically unpopular to those who wield authority.
And I think it's increasingly obvious, though, that the conservatives who'd like to move away from the consumer welfare standard and the Democrats who'd like to move away from the consumer welfare standard want to move away from it for entirely different reasons. So I think that'll be it'll be interesting to see how things play out because of that too. Because now we've, with the Google suit, for example, we now have a different administration, but a lot of state attorneys general attached to that, and there were no remedies proposed in that either, which was interesting. They did leave that one wide open. Going back to market definition, though, they did seem to. I think you're right, Paul, in that the notion of market definition that's being applied in a lot of these cases doesn't make much sense. And in that case, in particular, it's kind of like they gerrymandered 3 different market definitions and just threw them out to see which one sticks, and are kind of trying to get the right market definition in order to bring a case. So that's one really interesting element of it.
Yeah, this is it's an area that is so much in flux, and there's so much dynamism, and it's so hard for anybody. This is such a new space too. I mean, when you think about how much development has occurred in the past decade, it was so interesting. In my last job, I had the opportunity to go overseas a few times and meet with some of the leading Asian tech companies, and universally they are concerned about American tech companies, and that is the competitive threat that they worry about the most. So there is a tension that I don't think I've seen fully acknowledged when you talk about blocking companies from other jurisdictions from competing in the US, when you talk about US companies establishing global leadership, and yet when there's a challenge to the sort of product integration that they have to effectuate in order to build those leading brands. We can't have both of these things. I don't know how it's going to play. And Timothy, I know you're putting a lot of the blame on the Republican side here for not having a consistent view of liberty. And I hear that expressed a lot, but I also think the tech community made a strategic choice that came with a lot of risk. There was a coalition on the Republican side around liberty that encompassed a broad swath of the population, where folks would say, well, I may not care so much about your economic freedom to have low taxes and a big business, because that doesn't affect me, but I care about my freedom to have a gun and to not be ostracized for having traditional beliefs and so forth. And the tech community really moved pretty far to the left and kind of broke that coalition. And that was a risky move. I mean, that was move that assumed that what the enduring element of liberty would be the freedom to build a big company. And I don't think that is probably the most likely enduring element of liberty. And we're seeing that it's not. So now when you go in to meet with a Republican elected official, it's in a posture where that official may feel like you are directly targeting and threatening the folks who put that person in power. And that's not a favorable backdrop for having a meeting. That makes those conversations much tougher. And that's a much different framework than companies generally have or attempt to have when they go in to meet with a regulator, where they want to talk about all the common ground and what they're doing for financial inclusion and all these sorts of things. The tech community has chosen a very different path, and I think it came with quite a bit of risk.
Oh yeah, I know that's an eloquent way of putting the way I would put it more bluntly is that the Republicans now who are advocating this dramatic change in antitrust law see the opportunity to use those laws as a weapon against their political enemies simply because they are their political enemies, which has always been one of the major, if not the major, concern about antitrust laws is that it gives political officials the authority to penalize businesses not for doing anything wrong, but for taking a politically unacceptable position and putting themselves in a spot that politicians want to retaliate against them. And now that opportunity is before them, and I expect that that is clearly why at least some of the Republicans who are embracing this populist antitrust theory, it's clearly their motivation is solely as political retribution against their enemies, not to protect American consumers or defend constitutional or legal rights.
I do think it goes a little bit deeper than that, though, for some of these Republicans. I think they do really see these companies as an existential threat. I mean, rightly or wrongly, to their movement. And in some cases, the companies haven't done themselves any favor. That doesn't mean we should be using antitrust as a weapon, obviously. But Republicans lost the media a long time ago, and that went kind of to the left. They were able to get their views out there via social media, and now there's kind of they see this as maybe not having another avenue, I feel like.
Oh yeah, no, there's no question that this isn't what you're describing is the media angered the Republicans, and so the Republicans will use the antitrust laws to punish the media for basically First Amendment conduct, and that should be morally outrageous to every American, regardless of their political views.
So I don't think I'd go quite as far as Timothy's going there. When I was describing this phenomenon, I'm talking about the context in which you engage with a regulator. And I think it's always important for companies at least attempt to put context around their actions. And that's very different from saying that a regulator would specifically target a company for a political reason. But if a company can't put their actions in an appropriate context, I think oftentimes makes it harder for the company to justify what they're what they're doing. Although it was interesting to me that Senator Hawley's line of questioning around coordination on blocking certain participants seemed to be, I was trying to work through, it seemed to be some elements of an antitrust theory, but I couldn't quite piece together exactly where it was going. Somehow, if you coordinated to block the same people, that was some sort of restraint of trade. But maybe Timothy worked through that a little more thoroughly than I did.
No, the reason I was laughing was because I was looking at this thing yesterday that was very similarly amusing, which was a graphic that was circulating on Twitter that says, "Is it a monopoly?" And then it points these arrows at the words Apple and Microsoft and Facebook and all this, and then it says, and then points the arrows that say yes, even though all of these companies are competing against each other. I mean, therefore, they are not a monopoly. Look at all of those monopolies out there. You know, they're all those monopolies out there competing against each other. Why? We're just surrounded by monopolies. We need more aggressive antitrust policy. It's not a logical argument.
I do think it's a very DC problem to have, so to speak, to think that Twitter is a monopoly, though. I mean, if you look at the market share and who uses it and how often, it's mostly political. It's the rest of America is not getting their news or spending their day online on Twitter. It's such a bubble. Getting back to kind of some of the enforcement authority issues, I know this is more of a federal question than a state one, but one thing we've seen over the past couple of days, we've seen Senator Lee's One Agency Act. Any thoughts on that? I have some mixed feelings on it. I do like the general premise of having much clearer delineations of authority on these things. I don't know if it necessarily should be which agency it should necessarily be under, but I do like the broader purpose of the bill. Are there any thoughts on that? No.
I'm less familiar with this bill. I was actually about ready to. Yeah, I'm just less familiar with this bill. I'm sorry.
So he's seeking to solve the FTC DOJ antitrust overlap issue by putting it more under the DOJ.
Yeah. So that I think that concept it makes a lot of sense. And as a general rule, we have divided regulation among too many bodies, and that poses a number of problems. That's sort of where I started out here. We have too many financial regulators that disadvantages us in comparison to the Financial Conduct Authority in the UK, which centralizes authority, with the Monetary Authority of Singapore, with all these jurisdictions that we compete with. We can't effectuate regulatory change or policy change in an efficient way because we have so many pieces. And that problem is exacerbated because in our system, the president has such little control over so-called independent regulators that there are all sorts of restrictions preventing the president from directing policy across these regulators, and that is a very real problem. And just about your graphic that was showing all these things and then saying monopoly, and of course the implication is there should be enforcement. That's why I wanted to start with this visa action. Again, if you're worried about large tech platforms taking over sectors of the economy, boy, you'd better make it as easy as possible for any other sector to combine, because that's what the real competition is. And coming in there with these narrow market definitions and jamming at combinations and slowing down innovation, that's not going to be efficient on any level. And it's certainly not going to prevent the largest players from dominating a market. It's going to facilitate that domination. They're just going to come from somewhere else. It's going to come from a tech company into finance, as opposed to a finance company that can expand into other areas.
Yeah, the word dynamism is really the very apt. For those who may not have read it, Virginia Postrel's magnificent book, The Future and Its Enemies, from 1998, that uses the term dynamism to describe this the sort of Hayekian insight that economics is this process of growth and change, and the idea of trying to slice it up into these categories and then somehow freeze those categories in an unchanging way, whether it be through law or through common law decisions, or another instance actually that I've been working on this week is California's recent AB 5, the law about people who can be an independent contractor and who can't. And this law is enormously long because it truly tries to categorize every occupation in the state. And that means, of course, you have to go into these details, like a musician, except for a musician who participates in a symphony orchestra for a single live performance. The law really does differentiate at that level of detail. I mean, you can't do that, at least not with an economy that's living and thriving. And one of the real problems of antitrust enforcement, but any kind of economic regulation, is not creating these boundaries or these limits that restrict economic growth from the competitive process that, as you say, is really the true destroyer of monopolies, is free and open competition.
So we have 5 minutes left here. Any just general closing thoughts?
Well, first of all, thanks for the opportunity to have this conversation, and thanks, Timothy, for contributing your perspective here. And I think there are a lot of questions that are very open that will play out through the course of this century as to who is going to be dominant technologically, economically, which will no doubt drive militarily, and the regulatory structure and the enforcement posture that we are taking are going to shape these questions. And my fear is they are not shaping them in a positive direction. I am quite concerned that there is a giant conflict between the values that we state around American competitiveness and the regulatory and enforcement postures that we take that inhibit our ability to achieve those goals. There appears to be broad bipartisan agreement on American competitiveness, and yet there also appears to be a bipartisan agreement on taking actions that inhibit it. This conflict, I think, needs to be expressed, drawn out into the open, and we need to make a decision on how we want to move forward as a country and what we perceive as the greatest threats, because we need to be strategic and we need to be thoughtful and we need to be consistent in this area.
Yeah, I agree with all of that. And I would add that, we're having this conversation on Zoom right now because of the pandemic, which has caused us more than ever before to rely on companies like Amazon and so forth to supply us with the things that we need. And it would be astonishingly short-sighted for us today to start weaponizing antitrust law and against companies that have really stepped up and shown us their value that they provide to us. Not only that, but have shown us how vibrant the competition is for the technological services and so forth. So it would astonish me if at a moment like this, our policy choice was to take steps that ultimately end up killing the golden goose. It's crucially important that not happen. And that means adhering to the consumer welfare standard, adhering to pro-efficiency policies, protecting consumers instead of businesses, prioritizing free competition rather than government dictate, whether it be phrased as fairness or whatever it might be.
Thank you. Well, I'd like to thank both of you for coming on today. This was a great conversation. I thought that was definitely very enlightening for some of our audience, particularly since there's not enough coverage of the issue on a state level. So thank you both for coming out on a Friday, and have a great weekend, everyone, and a great Thanksgiving.
Thanks so much.